Our second speaker tonight is Kathryn L. Tucker, a graduate of Georgetown University Law School and Director of Legal Affairs for Compassion and Choices, a national nonprofit public interest organization dedicated to improving end-of-life care and expanding and protecting the rights of the terminally ill. Ms. Tucker practiced law with the Seattle-based firm Perkins Coie prior to moving to Compassion and Choices. She's adjunct professor of law at the Lewis and Clark School of Law, teaching in the areas of law, medicine, and ethics with a focus on the end of life. Ms. Tucker was adjunct professor of law at the University of Washington and Seattle University for many years. She served as lead counsel representing patients and physicians in 2 federal cases decided by the United States Supreme Court in 1997, asserting that competent dying patients have a constitutional right to choose a humane, hastened death with physician assistance. Ms. Tucker argued the Washington case in the United States Supreme Court. These cases are widely acknowledged to have brought much-needed attention to improving care of the dying. Ms. Tucker is also involved with state constitutional litigation involving claims of a similar nature, and she has successfully defended the Oregon Death with Dignity Act from attacks from the federal legislature and the United States Department of Justice. Ms. Tucker is recognized as a national leader in spearheading creative and effective efforts to promote improved pain care for seriously ill and dying patients. She served as co-counsel in the first case to assert that failure to treat pain adequately constitutes elder abuse, which resulted in a finding of liability and a jury verdict of $1.5 million to the family of the patient against the involved physician. That hurts. It just hurts. She also achieved a favorable settlement prior to trial with the involved medical center, including an agreement by the medical center to provide pain management training to its nursing and medical staff. Ms. Tucker was a principal author of legislation requiring pain management education of all licensed physicians passed by the California legislature in 2001. And she also defends physicians facing adverse consequences for treating pain attentively and aggressively. Ms. Tucker is listed in the prestigious directory Who's Who in American Law, was recognized as Lawyer of the Year runner-up by the National Law Journal, and is one of the nation's outstanding young lawyers by the American Bar Association. She appears frequently on television and radio discussing end-of-life care, end-of-life decision-making, and physician-assisted dying, and she speaks at many legal and medical educational forums on the same topics. Her work has been profiled by the National Law Journal, the American Lawyer, the Journal of the American Bar Association, Legal Times, George Magazine, Vogue Magazine, Time Magazine, People Magazine, and Health Magazine, among many others. The title of her talk is Physician Aid in Dying: When and Why Should This Option Be Available? What Happens When Aid in Dying is Legal? Please join me in giving a warm welcome to Ms. Kathryn Tucker.
Thank you so much, Shelley, and for inviting me here. It's just wonderful to be in Houston. And also thank you to Wesley for his gracious comments. We had a session before this one where we really got into it. But I have to say, everything that he just said, I'm in agreement with, and our only point of disagreement, I think, is that while I and my organization agree that when a patient is terminally ill, we must do everything to support that patient, to care for that patient, to love that patient, to offer options. We go a bit further and say we ought to honor the choices of that patient. And if the patient makes the choice to hasten impending death, we believe to support the patient is the right thing. So I will be talking, and I'm starting with an example of a patient who we worked with in Oregon, Charlene Andrews. She was dying of breast cancer. She had exhausted curative therapy. She had had surgery, radiation, and chemotherapy. And she had come to the point in the course of illness where there were no more curative therapies, and she was finding her dying process intolerable. She was a very independent woman. She wanted to be able to exercise a measure of control over her death. She did live in Oregon, so she had the choice available under the Oregon Death with Dignity Act. She knew she wanted to die at home, in bed, surrounded by her loved ones. And so she was able to make that choice in Oregon. I want to start on the lexicon subject. What do we call this? Because words do matter. When we speak of the choice of a mentally competent, terminally ill patient to control time of death, what should we call it? Wesley Smith wants us to use the word suicide. We and many others, including here is, for example, the American Public Health Association, reject the use of the word suicide. The APHA has said in a policy in 2006 that it's inappropriate to use that when speaking of this choice of a mentally competent, terminally ill patient. And similarly, the American Medical Women's Association has resoundingly rejected the use of that term as inaccurate. It is emotionally charged and inaccurate. The American Academy of Hospice and Palliative Medicine also rejects that term as inaccurate and emotionally charged. So we and I will use the term aid in dying during my comments tonight. It is currently legal only in the state of Oregon. It does occur in every state in the United States, underground, covertly, without safeguards, without regulation, without transparency. The Oregon law was passed in 1994. There was a period of delay when there was litigation about the law. That period ended at the end of 97, and implementation of the Oregon law began in 1998. So what is permissible in Oregon? If you are terminally ill, which in that state means 6 months or less life expectancy, as confirmed not only by your treating physician, but also a second physician, and you are mentally competent with the ability to make your own healthcare decisions, you must make multiple requests. These requests must be oral and written. There is a 15-day waiting period. You must be provided information about alternatives such as hospice care, and you must self-administer medications that your physician prescribes that would enable you to bring about a peaceful death. That's what's permitted under the Oregon Death with Dignity Act. So what do we know when, the lawsuit that I was involved with in the early through mid-90s, when those cases were litigated in the United States Supreme Court, there was no legal experience yet with aid in dying. And so there really wasn't any information about how a legal practice would work. We heard a lot from the opponents in those cases that if this option were available, there would be risks, there would be harms. We didn't have any data at the time with which to evaluate those arguments. We do now, and we're now 10 years later, 9 full years of reported data by the Oregon Department of Health. And so we're starting to see a lot of information about what happens when this choice is legal. Well, what do we know? It's not used that often. In Oregon, it's been roughly 30 patients a year who go through the entire process of requesting, obtaining the medication, and then using it. Many more patients actually get the medication than go on to use it. And many patients are simply comforted to know that they have that choice. What do we know? Demographic data is collected every year. Who is making this choice? One of the arguments that had been made early on was that patients without health insurance, the poor, the uninsured, would disproportionately make use of the law. In fact, that patients making use of the Oregon law are covered with health insurance. And interestingly, they're overwhelmingly enrolled in hospice. Wesley touted the benefits of hospice care. We too are advocates for good pain and symptom management, which is often found in hospice. Oregon, in the wake of passage of this law, has seen its hospice enrollment skyrocket, and Oregon now has upwards of 80% of terminally ill patients are enrolled in hospice. In most of the rest of the country, it's closer to 20% enrollment. People just don't know about it, or they don't get a referral for it, or they don't enroll in hospice care. That's not true in Oregon. The Oregon patients are dying at home. If you ask any American citizen what they think of how they'd like to see their death unfold, they all talk about dying at home. It almost never happens in most of this country, but it does happen in Oregon. And what we've also seen in this 10 years is the risks that were speculated about have not come to pass. There was a study that came out just earlier this year where researchers looked very carefully at the Oregon data and asked exactly the question, with the Oregon law on the books, do we see that vulnerable populations, and they identified 10 groups as being considered vulnerable. Among those were included persons with either mental or physical disabilities. Do we see any evidence of harm to those groups? Do we see any evidence of disproportionate impact in those groups? And the answer was no, absolutely not. The other thing that's starting to be clear from a review of what's happened in Oregon is not only have the risks not presented, but we've seen overall improvements in end-of-life care for every terminally ill patient in the state. So as I mentioned, hospice enrollment has skyrocketed. The provision of strong pain medications has increased in Oregon. And physician enrollment in continuing education to learn more about how do we treat pain and symptoms associated with terminal illness, that has also skyrocketed. And you are hearing from an advocate, so I'm sharing with you what I hope you will see as a neutral view. One of the things that's happened is other states have looked at the Oregon experience. The state of Vermont was examining whether it would pass a similar law. It has not yet done so, but in the course of its legislative consideration, the state of Vermont impaneled a task force to look carefully at the Oregon experience and concluded, and this is a quote from the task force, "It is quite apparent from credible sources in and out of Oregon that the Death with Dignity Act has not had an adverse impact on end-of-life care and in all probability has enhanced the other options." So I think we're seeing very much what the Supreme Court hoped we would see and intended we would see when it resolved the cases in the mid-90s by saying, we're not going to find a federal constitutional right today. We may do that in future, but for today, we invite the states to grapple with this issue. So the state of Oregon has done that. Other states have learned from that and are now issuing their own findings of what the Oregon experience has entailed. I should speak again briefly about the reality that although Oregon has legalized aid in dying, in the other states this does occur, and there's quite a lot of study that shows the prevalence of physicians being asked to assist a patient in achieving a peaceful death, and the incidence in which physicians agree to do that is quite high, as this data shows. There are also studies that when aid in dying occurs in the back alley, in the underground, that there are more complications and that it is a frightening, stressful experience for the patient and the family. So what about aid in dying being available outside of Oregon? I think that this data that we're seeing emerge really will be quelling most of the opponents' arguments. And I think that both in the state houses and in courthouses, judges and lawmakers will be influenced by what we see, particularly if you recall that the central argument against aid in dying in the Quill and Glucksberg cases was that risks would present. We now know that those risks do not present. And I think while we will likely see some continued opposition from certain organizations, I think it's harder for them to maintain tenable arguments based on risk in light of the data. I did want to share some comments since I am invited here to the Holocaust Museum, and probably many of you have particular interest in issues of the Holocaust. I did want to share not my thoughts, but the thoughts of a leading Holocaust scholar who was a board member at my organization until he died in 2004, and the author of this very well-known text called By Trust Betrayed by Hugh Gregory Gallagher. Hugh Gallagher was a leading disability rights activist. He was one of the very early pioneers. He himself had polio and was an early pioneer for legislation for access for persons with disabilities. And a particular interest of his was studying the medical programs of Nazi Germany. And I think we sometimes see opponents of aid in dying trying to analogize the choice for aid in dying to the Nazi experience. And I want to share with you what Dr. Gallagher would point out were the fundamental differences. Nazi Germany, the determination was made by the state that certain persons were inferior and disposable. The exhibit here, which is fabulous, shows all of that in some horrifying detail. In the United States, we're a country dedicated to individual freedom, and the state is limited in depriving individuals of those freedoms. The Nazi Germany gave medical profession unbridled power to control the lives and deaths. The supporters of aid in dying seek to expand individual autonomy and to diminish the power of the state to intrude into the most personal decisions that a person might make about their own life and death. And I know it's almost impossible to read, so I will read it verbatim, which I hate to do, but I think Professor Gallagher's comments are so insightful. This is a quote from an amicus brief that he submitted to the United States Supreme Court in those cases that I've mentioned. He says, quote, "The Nazis' euthanasia program offers a horrible example of how easy it is to go wrong when the state or a group authorized by the state is allowed to assume the power to judge the worth of another. Ironically, this program is now being used by some as a justification to deny Americans in terminal stage of illness the right to die with assistance. In fact, the German experience shows how important it is that the autonomy of people with disabilities be honored in all aspects of their lives. I do not believe that people with terminal illnesses should be denied the option of ending their lives in order to obtain relief from intolerable pain and suffering. This most personal of all decisions should rest between the person and his God. The medical establishment in Germany was authorized to provide mercy death for patients who, in the judgment of their physician, had lives not worth living. The program was authorized by Hitler in 1939 and placed under the direction of his personal physician. Although the program was called, quote, euthanasia, close quote, the vast majority of the people killed were not terminally ill or in great pain or even requesting death. The patients were given no choice over whether to live or die. The case of aid in dying is quite different. The patient with a terminal illness retains complete choice over whether to live or die. Neither the state nor the physician may decide based on their conceptions of the individual's quality of life. The individual must assess his or her own quality of life. This is true whether or not the individual has a disability. So that is perhaps brings this full circle to this particular exhibit and distinguishes a bit for you why the issue of aid in dying is quite the opposite of the Nazi medical program. And I close with this comment from a noted legal philosopher and scholar, Ronald Dworkin, who has this thought that to make someone die in a way that others approve, but that he believes a horrifying contradiction of his life, is a devastating, odious form of tyranny. Thank you.